aboard, everybody. Welcome back to Dr. Peter Glidden, your friendly neighborhood naturopath, your advocate for health, steadfast advocate for health, talking to you again today. Thank you very much. Now, this is a day, I've been telling you about this for a couple days now. We want to mark this day in big red letters on the calendar. I'm going to introduce my guest here in just a second, but first let me dial in his resume. Very happy to have this guest on board. Because what are we dedicated to here on Fire Your MD Now? What are we dedicated to? We're dedicated to truth. We're dedicated to justice. We're dedicated to the American way. We're dedicated to giving you the straight skinny about the stuff you didn't know you didn't know. And what I rail on every day is that information that is so far outside of your reference range that you didn't even know you didn't know it. That stuff specifically pertaining to your body and the metabolism thereof, and science-based, clinically verified alternatives to drugs and surgery, stuff that you can dial in right now, today, to make a difference in your life. Well, you know, this is a holistic venue, is it not? This is a holistic understanding of health, but the microcosm reflects the macrocosm and vice versa. And so our society, when viewed as a whole, there's a whole lot of stuff going on here in politics, right? You know, everybody hates politics, but we have to deal with it. My guest today is one of the staunchest advocates of holistic health in the political arena that currently exists. Jonathan Emord has been licensed to practice law since 1985. He began his career as an attorney in the Federal Communications Commission during the administration of Ronald Reagan. Jonathan Emord is admitted to practice in the states of Illinois, Virginia, the District of Columbia. He is admitted to practice before the United States Supreme Court, the United States Courts of Appeal for the 4th, 7th, 9th, 10th, and federal circuits, the United States Courts of International Trade, the United States Courts of Federal Claims, the United States District Courts for the District of Columbia, Eastern District of Virginia, Northern District of Illinois, Western District of Wisconsin. He is the only non-scientist member of the Board of Directors of the Certification Board for Nutrition Specialists. In 2010, he became the first person awarded the title Honorary Nutrition Specialist by the Certification Board for Nutrition Specialists. He has sued the Food and Drug Administration 8 times, sued the Food and Drug Administration 8 times, my hero, and he is routinely consulted by industry, Congress, and the media on regulatory issues that regard health freedom. He is called the Dragon Slayer because of his lawsuits against the Food and Drug Administration. Ladies and gentlemen, it is my great honor and privilege to introduce to you Jonathan Emord. Jonathan, welcome aboard.
Good to be with you.
Let's give him a round of applause, shall we? Jonathan Emord, thank you so much. Let me dial this in here. I knew I could do it. There he is. Jonathan Emord, ladies and gentlemen. Thank you so much for taking time out of your busy schedule to be here with us today on Fire Your MD Now. Now, Jonathan, you've sued the FDA 8 times, right? Let's give us a little bit of a background about why and what that was all about.
Well, we probably have sued the FDA maybe 12, 13 times. We've defeated the FDA in federal court 8 times, 7 times on First Amendment grounds. And it all began in 1999 with the Pearson versus Shalala decision of the United States Court of Appeals for the D.C. Circuit. And that court held that FDA violated the First Amendment when it censored a number of nutrient-disease relationship claims for supplements, not least of which was their censorship of the folic acid neural tube defect risk reduction claim, which, created this decision was a landmark decision in that it created a new regime at FDA. FDA could no longer compel parties to satisfy their significant scientific agreement standard as a condition preceding to communicating health information. So Instead, they created a qualified claims regime consistent with the decision of the court. But despite doing that after being sued additionally by us a number of times to force them, they really have never abided by the decision of the court and have violated its principal direction to the agency, which was to allow claims to allow claims really as the rule. The court said that FDA was to make suppression the exception and to make disclosure of information the rule.
Whereas, in point of
that.
fact, they've done exactly the opposite, right?
That's right.
Yeah.
And so we've battled the agency in a number of circumstances over the years, defeating them repeatedly, thank goodness. And despite those victories, the sad reality is that this agency is a bit of a rogue and refuses to abide by the rule of law, which is an outrageous constitutional affront to our republic. And they operate as a dictatorship, essentially, independent of the constrictions that apply under the Constitution, under their enabling statute, and under decisions of the courts.
Well, we talk about this all the time here on this show, that absolute power corrupts absolutely. And this is the way that it goes, ladies and gentlemen, even though the Food and Drug Administration has been ordered by the federal courts to make it mandatory, make it okay for vitamin distributors to say, you know what, there is a massive amount of evidence to support our claim that selenium supplementation reduces the occurrence of breast cancer, reduces the occurrence of prostate cancer, reduces the occurrence of colon cancer, reduces the occurrence of lung cancer. They still put up roadblocks against us because why? Because the Food and Drug Administration is an out-of-control, for-profit, monopolistic juggernaut funded entirely by pharmaceutical money. And when you hold all the cards, you can do whatever you want, even when the federal government orders you to the contrary. Now, it's just crazy, Jonathan. I mean, this is just a crazy situation. We wouldn't put up with this in any other field of endeavor, but in medicine, it's just par for the course. Tell me a little bit, please, about the qualified health claim that you guys put forth for the selenium, in regards to selenium.
Well, a number of years ago, I guess it's 2, maybe 3 years ago, we won a case called Alliance for Natural Health U.S. versus Sibelius, and Youngevity was a contributor to that case. Dr. Schrauzer was one of the scientists relied upon to support that claim, and the FDA censored the claim after allowing it initially. We petitioned the agency initially on behalf of Youngevity to get the claim, and the agency authorized the claim then after it occurred on the heels of 2 of our victories on First Amendment grounds against the agency, so they were rather timid to tempt the court that much. So they allowed it, and then they unilaterally reversed their decision and revoked the claims. And then we sued them on that, and we won a decision against them in that Alliance for Natural Health U.S. versus Sibelius, authorizing a qualified claim associating selenium with a reduction in the risk of certain kinds of cancer.
Now, by my way of understanding, in order to get the claim in the first place, literally you had to come to the court with truckloads of documentation supporting the relationship between selenium and the reduction of this breast cancer, right? I mean, is that how it went?
Well, I guess it depends on the size of your truck, but we had a considerable amount. I would say if you put paper together and from floor to ceiling with scientific evidence and reports, we probably were able to put one stack up to the ceiling. Thousands of pages of scientific evidence associating selenium with cancer risk reduction.
Yeah, see, this is one of the most, to me, this is one of the most egregious cultural myths that exists in the United States today, and of course it's perpetrated by the pharmaceutical industry, is this notion that naturopathic medicine, that chiropractic medicine, that alternative quote-unquote types of medicines are unscientific, they're unproven, they're undocumented, and just the reverse is true. And even though we have mountains, literally mountains of scientific research, mountains of evidence to support our case, because the powers that be are all about drugs and surgery all of the time, and because they hold all of the cards, we have to jump to their tune. We have to sue them in federal court, and even then, when we get a positive lawsuit, they don't abide by the findings, and because they own the show, there are no repercussions. So what the heck are we to do?
Well, I think the Associate Director of the Office of Drug Safety at FDA, Dr. David Graham, said it best when he described the agency in this way. He said, FDA is inherently biased in favor of the pharmaceutical industry. It views industry as its client whose interests it must represent and advance. It views its primary mission as approving as many drugs as it can, regardless of whether the drugs are safe or needed. And a comparable statement was made by comparable statements have been made by many FDA medical reviewers, those who review drug applications, including Dr. Ronald Kavanaugh, who said this. He said, "There is irrefutable evidence that managers at the Center for Drug Evaluation Research have placed the nation at risk by corrupting the evaluation of drugs and by interfering with our ability to ensure the safety and efficacy of drugs. While I was at FDA, drug reviewers were clearly told not to question drug companies and that our job was to approve drugs," unquote.
Ladies and gentlemen, the books have been cooked. The books have been cooked, and your health is at stake. And this is the kind of stuff that goes on all of the time behind the scenes. And if it weren't for people like Dr. Wallach, if it weren't for people like Jonathan Emord, if it weren't for those of us in the holistic health community standing up on a hill, waving a flag, saying, hey, wait a minute, let's, look at the man behind the curtain, let's pay attention to the man behind the curtain, God only knows where we would be. Ladies and gentlemen, you want to dial this show in today. Tell your friends, tell your family about it. Jonathan Emord is on with us for the full hour. Peter Glidden, your friendly neighborhood naturopathic physician, have the great pleasure today to be talking to Jonathan Emord, the Dragon Slayer. Check out his website, or you can click on it right there on the front page of fireyourmdnow.com. We put a link to it right up on fireyourmdnow.com. Click on it and pass it around, because that's how we roll. Now, Jonathan, of course, I'm a naturopathic physician. I've been licensed since 1992. I have 24 years of clinical experience. I love the naturopathic medical profession, and, life being what it is, there is a lot of, I think, inherent jealousy in the profession, and there's just a lot of misunderstanding, especially with the new docs that are being rolled out, because really, we don't just have that good of a handle on the evolution or the history of naturopathic medicine in the United States. And so once and for all, I would like to set the record straight right here, live on, or international internet radio, the relationship that Dr. Wallach, my colleague Dr. Wallach, and his company, the Longevity Company, has had with you and with battling, the Food and Drug Administration and the government, quote unquote, in order to have our rights taken care of as consumers of naturopathic medicine. Now, you already mentioned his relationship with you and the Alliance for Natural Health versus Sibelius. What else has Dr. Wallach done in concert with you?
Well, Dr. Wallach was the plaintiff in Wallach versus Crawford, which is cited at 2005 Westlaw 6054963, and that was a case that challenged FDA's efforts to restrict what could be sent out in third-party literature, and it resulted in a essentially substantively split decision. FDA got a part of the decision, we got a part of the decision, but that was waged in the Southern District of California, and that was Dr. Wallach as the plaintiff. Alliance for Natural Health U.S. versus Sibelius involved the Wallach-sponsored petition for a selenium health claim and the work of Dr. Schrauser as a scientist in support of the selenium research. So that was definitely a case involving Dr. Wallach. And Whitaker versus Thompson, which was about antioxidant vitamins and cancer risk reduction, Youngevity, Dr. Wallach played an important role in that case, and were among the parties petitioning the FDA to get that claim through. And so, there's been considerable activity. And not only that, Dr. Wallach has been a constant advocate for decades of allowing consumers to make informed choices based on information concerning the effects of nutrients on disease, and has been a pioneer, as everyone knows, in creating formulations that address nutritional deficiencies that may be responsible for particular disease states or for heightened risk of disease. So, that's a lifelong effort on his part, so it should come as no surprise that he involved himself in these cases.
And, of course, also on a more personal note, I think Dr. Wallach's relationship with you and your wife was also something to be concerned. Tell us about that.
Well, I spoke at a Youngevity conference many years ago in Puerto Rico, and at that conference, one of the top distributors of Youngevity came over to me and talked to me, and I was fleeing from her, frankly, for several years because I was stupid. But ultimately, I did marry Cheryl, and I'm a much better person because of it, because without question, she's the better part of this relationship. But she's a great person, and were it not for Youngevity and her involvement with it and Dr. Wallach's support of her, I suspect that we never would have come into contact. I wouldn't have known that she existed.
Yeah, it's fun. It's funny how life goes like that, isn't it? It's like the fellow said. Well, you want to know how to make God laugh? Just tell him your future plans, right?
Yeah. Well, I think Dr. Wallach is a perfect example of a rugged individualist who is a pioneer, and who, like all pioneers, he's not a delicate person. He's not a lily. He is a lion, and he charges into the den with the other animals that are present that could kill us and fights them. And I think, he ought to be applauded because he has taken the step of stridently advocating nutrition as an alternative in the care of people, and particularly now in these economic times, having an affordable option that works is critical. So
you're hearing it right here from the horse's mouth, ladies and gentlemen. The Dragon Slayer himself, Jonathan E. Mord, constitutional lawyer for the nutritional supplement industry, for the alternative health industry par excellence. We've got it on tape right now. Stick around. When we come back, we're going to be talking about stuff that's going on right now with the Food and Drug Administration that you need to know. Welcome back, everybody. Dr. Peter Glidden, your steadfast advocate for health. Talking today to Jonathan E. Mord, the Dragon Slayer. Didn't know law could be so fun, did you, folks? By the way, this is Law Week tomorrow, and Thursday and Friday. We're going to be talking to Clinton Miller. It's going to be a 3-day series about the Dietary Supplement Health and Education Act, also known as DSHEA, which is the law which allows you to get nutritional supplements without having to go to an MD for a prescription. We're going to be dialing it in with Clinton Miller for the rest of the week. But right now, for the full hour, we've got Jonathan E. Mord. Please check out his website. You can access it right there on the front page of FireYourMDNow.com. Now, Jonathan, all things being equal, nobody can do everything all of the time. Our expertise is health. Your expertise is the law as it pertains to nutritional supplementation and the nonsense perpetrated by the Food and Drug Administration. What's going on right now? What are the hot button issues that we need to be aware of?
Well, the FDA is enforcing vigorously its good manufacturing practice guidelines for dietary supplements, and as we had an economist evaluate the economic impact of that enforcement, and without affecting any demonstrable change in the quality of supplements, in other words, without improving the quality of supplements at all, this enforcement, which is based on process controls, not on finished product testing. It's costing about $150,000 to $200,000 a year for each dietary supplement company in the United States, more for some, less for others, but on average that amount. And that's causing a number of firms to go under and to reduce their availability of products. The FDA admitted that that effect would occur, saying that this would reduce the number of dietary supplements on the market, increase their cost, and cause a number of firms to close. They did that after we filed our comments with our economic assessment with OMB, Office of Management Budget. OMB withheld approval of FDA's GMP rule until FDA revised its economic assessment. And to everyone's surprise, they did that, admitting their earlier assessment to be an error by accepting our assessment almost in its entirety. So this is now happening. And in addition to that, Congress passed the Food Safety Modernization Act, which gives the FDA commissioner almost unbridled discretion over declaring any supplement to be adulterated, even without proof of it causing injury, just on the supposition that it may at some dose level create injury, which of course is a truism, because everything, including water, at some dose level would cause injury. Nonetheless, she has that discretion now under federal law, and this is creating a grave danger for the supplement marketplace, because at any point she can declare specific nutrients to be unavailable, as she did in the case of ephedra.
So this is a paper tiger that the Food and Drug Administration has created under the guise of making nutritional supplements safer. They actually don't make nutritional supplements safer, but what they do require is a lot more paperwork by the nutritional supplement manufacturers, which increases their overhead, which then is going to force the nutritional supplement industry out of business. And in addition to that, at their whim, without any scientific evidence, without any basis of fact whatsoever, they can declare vitamin C toxic. They can declare calcium toxic and take whatever they want off the market. Am I hearing that correctly?
Well, that's right. There is virtually unbridled discretion in the hands of the FDA commissioner. After the Nutraceutical Corporation decision, which we won at the district court level, was reversed on appeal in the 10th Circuit, and after the GMPs were issued and the Food Safety Modernization Act, there really is nothing left to the requirement that FDA prove something to be unsafe before it declares it to be adulterated. Instead, it may now declare any ingredient adulterated, because at some dose level, every ingredient may cause injury, and that is sufficient to say that the ingredient poses a risk to public health under the new regime.
Yeah, one of life's greatest ironies. The leading cause of death in the United States is MD-directed medical treatment. 780,000 people, approximately, it's a conservative estimate. 780,000 people a year are killed by MD-directed medical treatments. There are over 35 drugs and medical devices which were approved by the Food and Drug Administration as safe and effective, and they hurt and killed people. There are class action lawsuits now against the pharmaceutical companies that made those devices, but nobody has gone to jail. There's, slaps on the wrists, but, nothing of substance, not even any financial fines of any substance, and the beat goes on. And yet, we have to look out for those vitamins. We have to look out for those nutritional supplements. This is clearly a device that the Food and Drug Administration has dreamed up to do an end around of DSHEA. Wouldn't you agree?
Well, yes. The FDA is really a captive of the drug industry, and the drug industry has sat upon the sidelines of the supplement industry for decades, only reacting to force FDA to slap down companies that may make claims that it doesn't like. But now it's in a different posture. It has succeeded, finally, after numerous attempts, at coming up with a mechanism that can really force the consolidation of the supplement industry and tame industry players so that they're not as vocal in their claims and they're not as critical of the FDA. And that then leads to market concentration, which means higher costs for products and fewer options to purchase the products. And it is precisely that kind of market that then enables the drug industry to purchase both sources and companies that supply these products and create a new regime with FDA where, for the first time, claims will start to be allowed. Supplements will be treated more like over-the-counter drugs, and the drug industry will be the favored regulatee. The FDA will have its say. At a point when the drug industry acquires half or more of the supplement marketplace, the law will change in the to favor supplements and their claims. Until that time, it won't. And just to give you an example, if time permits,
you bet,
of just how extraordinary the control of the drug industry is over the FDA. There's a Sanofi Aventis drug called Ketec. It's a super antibiotic, or so it was claimed to be. And during the review of the application for that drug, the medical reviewers at FDA were concerned because one of the principal clinical trials seemed to be too pristine, seemed to be too perfect. There were far fewer dropouts than could reasonably be anticipated, and the results were extraordinary, far greater than they had anticipated as well. So they began to ask questions, the medical reviewers of the drug company, asking for the empirical data, show us the participants in the clinical trial and their informed consents and their addresses and so forth. Well, they didn't get responsive information, so they notified the FBI of their concerns, and the FBI discovered that the Sanofi Aventis clinical trial never actually occurred.
Wow.
Despite that, the medical reviewers had argued that now this makes it necessary for the commissioner to deny drug approval.
Right. And
anyone in the right mind would think that. But the commissioner of the FDA overruled the medical reviewers' objections and approved Ketec as an antibiotic. It's in the market today, and it bears claims that include the claims that were only supported by that clinical trial.
Which was completely fabricated and made up and
right.
never happened.
So if that's not proof positive of the extraordinary control and influence of the drug industry over the agency, I don't know what is. Without a supplement company undergoing FDA review, and it was discovered that they had filed false statements with the United States government establishing something to be material to an approval or an assessment, they would be prosecuted. The executives of the company would be thrown in jail, and the company would be largely bled of all of the finances that it has. But not so with the drug industry.
Well, and this speaks to a greater issue, and because we're holistic in our mindset here, we always like to trace it back to the root cause, and certainly those of us in the know for decades now have seen to varying degrees and ascending degrees the power that the pharmaceutical industry has over the medical market in the United States. And I mean, this is just an extraordinary example. Why do you think, when we trace it back to the root, I mean, does it just go back to money? Is it just massive amounts of money? Or what is it that's at the root of all of this skullduggery? What do you think it is when we tap it right down to the root?
Well, that's what my book, The Rise of Tyranny, is all about, and I've written about this as well as the censorship effects we've been talking about, which I explain in Global Censorship of Health Information, another book. The history of the FDA is really one of a delicate dance with the pharmaceutical industry. At the very start, the agency was really more or less a safety operation that would look for extreme cases of lack of safety in the food and the drug market and would call people to task to correct those errors. Later on in the 60s, with the Kefauver-Harris amendments to the Food, Drug, and Cosmetic Act, the drug industry took center stage in creating a regime with the FDA for approval of drugs, assessing both safety and efficacy. But under the terms that the drug industry wanted, it may be a surprise to people that the principal barrier to getting a drug approved is not the approval process per se, but rather is the cost of getting your submission there. It costs $1 million to just file a drug application with the FDA, $1 million. And then you have to have conducted enough clinical research to support the application, which ordinarily may take 5 or 10 years and cost hundreds of millions of dollars. But the ultimate key here is that the drug industry controls the FDA through the Prescription Drug User Fee Act. About 80% of the cost of the operation of the Center for Drug Evaluation Research is paid by the drug industry. So you have the party paying for its own review, and of course there's tremendous bias there. But not only that, FDA never conducts its own independent research of drugs in the sense of doing clinical trials. It never does its own clinical trials. It accepts the clinical trials of the drug sponsor, and there's an obvious conflict of interest. Likewise, it accepts the safety determinations of the sponsor without doing its own safety assessment. Consequently, numerous drugs are approved that are unsafe, and the review parties, the parties responsible for review of the drug application and approval of it, are given the role of post-market surveillance. So they have an inherent interest in keeping the drug on the market because they determine that it should be approved. FDA has a long history of censoring reports that are negative about drugs, ostracizing and excluding scientists who make statements that are negative about drugs. And Congress does absolutely nothing to put this into check, despite numerous statements made in testimony of medical reviewers to Congress of this corruption. Congress has done absolutely nothing to rein it in. The reason for that is that the review committee in Congress, Energy and Commerce, their pockets are filled by the lobbying groups for Big Pharma. And the same is true of virtually every member of Congress to a lesser degree. As Dan Burton, congressman from Indiana, said, if pharma wants something bad enough, it'll get it. If it doesn't want something to happen, it won't happen here on Capitol Hill.
Stay with that thought. Ladies and gentlemen, absolute power corrupts absolutely. If you're not angry, you're just not paying attention. Stick around. More to come with the Dragon Slayer, Jonathan Emord, after these messages. Again, don't even think about touching that dial. Dr. Peter Glidden, very happy to be with my guest, Jonathan Emord, the Dragon Slayer. Now, Jonathan, in the last 5 minutes of the show, before we get into the nitty-gritty here, where can my listeners pick up copies of your books? Where do we go to get that info?
Emord, EMORD.com, and if you scroll down to the bottom of the front page, home page, you'll see the books scrolling across the bottom, and you can hit the book and have a secure link to Amazon to purchase it.
Okay, very good. Emord.com. And by the way, we have posted a link to Jonathan Emord's website on the front page of FireYourMDNow.com. So if you're listening to this radio show on the Internet, you're already there. Just click on the link for Emord.com and follow the bouncing mouse and pick up these books, because what do we say all the time? You don't know what you don't know, and knowledge is power. So it seems to me that the end game here of the pharmaceutical industry is to make it so expensive for nutritional supplement companies to make their supplements that they go out of business. And then as they go out of business, the pharmaceutical companies buy up the nutritional supplement companies until they own the lion's share of nutritional supplement companies. And then once they do, they're really going to step up the regulation, and it's game, set, match. Is that kind of how it's going to go?
Pretty much, except for the end there. Actually, once the drug industry controls over half of the supplement market, the claims wars will largely disappear, as the government will accommodate its principal regulatee in making health claims. So what will happen is there'll be a quid pro quo, and that is FDA will require that they have greater control over the manufacture and distribution of supplements, perhaps under a licensing regime through over-the-counter drug status or something like that, in exchange for which the drug industry will be given greater FDA-approved claims that will include therapeutic claims. So what is happening is a slow bleeding of the supplement marketplace, a destruction of companies and a slow bleeding of others, making consolidation of the market necessary to survive. And the upshot of that is that consolidated entities will be a better choice for drug companies to buy. So it's a method of control that is indirect. The direct methods were all stopped variously by us and by others who fought the FDA. Then FDA seized upon this idea that if it linked its regulations to public safety, it could virtually regulate out of existence supplement companies without ever having to prove any end product unsafe, simply on the idea of a change in its risk calculus.
So the million-dollar question that's burning in all of my listeners' ears right now is, well, what can we do? What are your recommendations?
Well, we have to vote out of office a lot of rascals, but recognize, as I explain in The Rise of Tyranny, that 9/10 of all federal law is not the product of those we elect, but the product of the unelected heads of the bureaucratic agencies, including the FDA. The FDA controls 1/4 of the market. 25% of the market is subject to significant regulation by FDA, with virtually no constraints on their exercise of authority. Not by the courts, not by the Congress, not by the American people, because the head of the FDA is one person who is unelected. So we have to reduce the size and scope of government. We have to restore the non-delegation doctrine, which means Congress has to be responsible for every rule. I've written a bill for Congressman Ron Paul called the Congressional Responsibility and Accountability Act that would prohibit any rule from having effect unless Congress adopted it through the standard means of passing legislation. That would eliminate a lot of regulation and would significantly slow down the ability of these agencies to strangle segments of the market. They regulate to determine who will be winners and losers, and that determination is oftentimes made with regard to the post-government employment prospects of the people in these positions. So, say, for example, the FDA commissioner would like to live like a queen for the rest of her days after she leaves the FDA. Well, she has to carefully select from among the drug companies those that she'll favor and those that she won't. And those that she favor will pay her back handsomely when she leaves.
Unbelievable. It all goes back to money. Ladies and gentlemen, my very special guest today, Jonathan Emord, thank you so much. We could talk for hours. I look forward to having you back at some point in the future. Keep up your work. You are everybody on this listening audience's new hero. There he goes, ladies and gentlemen. Jonathan Emord, thank you so much for your time. I look forward to talking to you again in the future. Let's give him a big round of applause and check out his web.